Okay, this is Pichet versus Assessment and Relationship Center LLC, and this is the plaintiff's motion for an order that the judgment is satisfied, and it's the defendant's counter motion for the same thing. And if I could first have appearances for the record, please.
Good afternoon, Your Honor. Peter Brown on behalf of the plaintiff and counter defendant, Michelle Pichet, and also the Garnachie Wellness Institute of Michigan.
Attorney Tina Gray, Your Honor, on behalf of ARC and Dr. B. Craig Smith.
Okay, thank you. I think you filed first, Mr. Brown, if you want to go ahead.
Sure, Your Honor. I think both motions really are the same issue, the counter motion that was filed by ARC. Really, we're trying to determine whether the judgment has been satisfied and therefore whether the garnishie's obligation under the garnishment have been satisfied. I believe with the supplemental briefs that were filed by both parties yesterday, I think we've flushed out most of the factual issues here. So I won't spend a lot of time on that unless the court has any specific questions, but we would submit to the court, Your Honor, that there is currently, as of today, a balance on the judgment in the amount of $1,317.92. I do have a check with me currently from the garnishee for that amount. The issue really what I think is currently before the court is how judgment interest is calculated, and the parties have a disagreement as to whether interest continues to accrue on the portions of the judgment that have been satisfied. So just to back up briefly as to how we got here, there was obviously a judgment that was entered on January 26th of 2018. That was a judgment on the counterclaim. The counterclaim was filed on February 6th of 2017. There had been periodic garnishments that were being made bi-monthly by the garnishee. The garnishee had records of those garnishment payments that were being withheld from Ms. Pichet's paycheck and then forwarded to counsel for ARC. There became a point in May of this year, on May 4th, where based on Ms. Pichet and the garnishee's records, that there were $884.60 that were remaining on the judgment. Ms. Pichet submitted that payment. Along with that, the garnishee stated that we feel that this is based on their calculations at that point, that the judgment had been satisfied. On May 19th, ARC provided a response claiming that there was $3,139 that was still remaining on the judgment. Obviously, at that point, as of mid-May, there was a bona fide dispute as to what was owed, because Ms. Pichet and the garnishee's records were clearly different than what ARC's were. So following that, ARC filed a notice of failure for the garnishee's failure to continue to garnish Ms. Pichet's paycheck. That's when I was retained, Your Honor. I ran calculations, and on the 22nd of June, I sent correspondence to ARC's counsel attempting to resolve this. I should back up. Back in May, when the garnishee stated that their records indicated that the judgment had been satisfied, they provided records to ARC's counsel indicating, here are all of our payments that we're showing being paid. There was really no response that there had been any payments that were not received by ARC. So I got involved in June. I submitted those same records to ARC's counsel stating, here are all the payments that we show being paid. Here are our interest calculations. Is there something that we're missing? Is there a discrepancy in those records? What's the issue? I received no substantive response to that for months. And so I was hoping this could be resolved if there was something where our records were not matching up, if there was discrepancy in the interest calculations. And I advised ARC's counsel that we have this notice of failure where ARC is claiming that the garnishee should have continued to make these garnishment payments. And I said, I have a response to that that's due within 28 days. Can we work this out? Received no substantive response. That prompted our motion for the satisfaction of judgment, claiming that we, in fact, argue that based on our records, there was actually a $423 overpayment. It wasn't until the response to our motion And the counter motion was filed on September 17th. That finally, for the first time after several months, there were some issues raised as to whether certain payments had been received. It's specifically the last two payments in September. Based on the supplemental pleadings that we filed yesterday, it was determined that those two last garnishment payments from 2019 were in fact withheld from Ms. Pichet's account, from her paycheck. But for some reasons unknown, we do not know whether those checks were sent. We do not know whether those checks were sent and received and never cashed, or sent and received but never cashed. So we do acknowledge that they were not withdrawn from the garnishee's account. So we know that those payments were not made. I believe there was also a $15 garnishment fee that was not previously disclosed prior to the response. So we reran the calculations, and we would now submit, Your Honor, that there is $1,317.92, which we are prepared to pay today. The issue on the interest, this is a legal question. It seems to me the way we would calculate judgment interest, you take the entire amount of the judgment as of the date of the judgment, along with attorney's fees and costs. You back it up to the filing of the complaint, or in this case, the counter complaint, since this was a judgment on the counter complaint. You would then run the statutory interest forward, and then post-judgment, there would be a credit for any payments made, and interest would accrue only on the balance of the judgment going forward. If you do that, Your Honor, as we submitted, I believe it is Exhibit M to our supplemental brief yesterday, we went through, we backed it up to the counter complaint, the date of the filing of the counter complaint on February 6th. We provided for additional amounts that were the costs, the post-judgment costs on the date that those costs were incurred. We've included all of the payments that were made. Obviously, the last two garnishment payments in 2019 were not included, as we've determined that those were not in fact cashed or received by ARC. And at that point, we've run that interest forward, and we do not accrue interest on portions of the judgment that have been satisfied. Obviously, opposing counsel suggests that interest should accrue on the entire amount of the judgment until it's completely satisfied. And I guess in closing, Your Honor, I put a brief example in my brief. I realized today that the math was a little bit wrong on that, but the example I tried to provide would be if there's $1 million judgment, and the day after the judgment is entered, the debtor provides a payment of $995,000, and there's only a $5,000 balance on that. And then 5 years later, there's trying to be a determination on how much interest accrued over those 5 years. We would submit to the court, Your Honor, the way that is calculated is there's the $1 million judgment. That $1 million is backed up to the date of the complaint. Interest accrues pre-judgment on that entire $1 million. And then the day after the judgment, if there is a $995,000 payment, it would just be the interest plus the remaining $5,000. That interest would accrue on that for the next 5 years until the final payment is made. Interest would not accrue for 5 years post-judgment on the $1 million. I think that's the issue. So we would submit, Your Honor, that any satisfied portions of the judgment, interest doesn't accrue on that. It's only for the balance of the judgment post-judgment. I'd be happy to answer any questions you may have.
I don't have any. Ms. Gray?
Thank you, Your Honor. We also submitted a supplemental brief, and I do think the issues when this was first presented to the court, the one side was there had been an overpayment. They were asking for a refund, and there has been a dispute that's been clarified concerning two payments that they thought were made that we now know were never received or made by us. And nobody has any explanation for that, but there's clear agreement that two payments that they had previously thought we received, we did not in fact receive. We have provided to the court in our original filing a copy of each and every check along with a transmittal letter from the garnishee for every payment we received. So the legal issue that is in front of this court really is about the interest calculation, because I think the law is clear with the court rules as well as the statutory language that interest accrues on the judgment amount. And there are some policies here that support that you need the interest to be accruing on the judgment amount, and there's no language whatsoever in these statutes or the court rule that talks about accounting for payments made. It talks about how to satisfy the judgment, and it talks about whether you're going to make payments towards the judgment through the clerk of the court. And as we cited in our supplemental response that we filed with the court yesterday, under the court rules, if you had gone down, using his example of the $1 million judgment, if you had gone down and paid, 950, well, paid everything but the $5,000 on that $1 million judgment, then yes, if you'd paid it to the court clerk, interest would stop at that point because the court rule says so. But there is nothing in this situation. It would be an absolute accounting nightmare to do what he is suggesting, which is to every time you receive a check from the garnishee, you're supposed to apply it to interest, I guess, and then if there's any remainder, you're supposed to pay down the principal judgment. There's no language that talks about that. And here, then the question would even be, well, are you supposed to do that exercise every 6 months? Because you compound interest every 6 months. So then I'd be guessing whether what the legislature meant was, if you are following his logic, if you are supposed to somehow account for these payments, when do you do that? I've never, ever done that. And the policy here, not only are we trying to follow what the court rules say, the court rules are very clear on how to do this, and the statute and the language says that the interest accrues on the judgment amount. There is zero language except for paying money to the clerk of the court for how to account for interim payments being made. This is a public policy too. We want people to pay their judgments swiftly. As Your Honor knows, we have been in this lawsuit since 2016. We have been to the Court of Appeals twice. We have been to the Michigan Supreme Court. This is a long-standing judgment, and we have tried very diligently to collect. I believe that we have submitted the appropriate method for calculating this interest. We have done it through the affidavit of Attorney Bradley Horton. We have attached our spreadsheet that shows how he calculated that, as well as his description for how he calculated that. So it is simply following the case law that we also supplied to this court, which is to calculate 6 months from the day of the judgment. And I do just want to, at this point, say, I'm not looking past the face of the judgment. The judgment itself has an interest calculation on it. And as we set forth in our spreadsheet, the judgment amount is $22,530. On that judgment document, there was already interest included in that judgment, and that interest was $1,185.95. I do not think we look past what's already been an entered judgment of this court and ask the question of whether that interest should be changed at all. I think that is an issue that is time barred and is long since waived. We are here on post-judgment interest. And in terms of how we've calculated interest and the notice that we've provided along the way, as we set out in our original response, we have provided accounting and statements in October of 2018, in January of 2020, again in May of 2020. So we have followed what the court rules require with regard to letting Ms. Pouchet, as well as the garnishee at that time, know what the current balance is concerning the payments being made and how much is left to still be paid. So it is our presentation to this court based on our supplemental pleadings, and all of us have had the opportunity to double check our math. And we too found an error because a payment that came in during the COVID shutdown was not properly reflected on our statement that we put out in May, and we made that correction. And we've definitely gone back and double checked to make sure that we are calculating the interest in a 6-month interval from the date of the judgment, as opposed to a calendar 6 months. So instead of just calculating it in January and July, like I think some of us used to do before the case law clarified that, we're actually using 6 months as a chronological time span, as opposed to 6 months on a calendar. So we made sure that that spreadsheet was updated there. It's my submission to the court, and in the documents that we've supplied to the court, that we are still owed $2,814.22. The difference between what he's offering to pay today and what we're claiming is still due is $1,496.30. So really the issue in front of this court is, have we calculated this correctly and we're owed an additional $1,496.30 or not? So that is the legal question, I think, that's before this court. And it is, one way is how you mechanically calculate the interest, and the other is, do you account for the payments that are made, or do you just go off of interest is calculated on the judgment amount? Thank you, Your Honor.
Thank you. I won't offer any other argument time since this has been very well briefed with initial briefs and supplemental briefs as well, and I have studied it all. And it appears clear at this point. We had a factual dispute last week, which is why I asked the attorneys to adjourn this so we could work out whether the two payments were made or not. So the factual dispute's been resolved, and I agree with both attorneys that what we're left here with is really a legal question, and that is how to calculate the interest. The interest calculation is in part dictated by the statute. That's MCL 600.6013, and it's subparagraph 8 that is applicable. ARC, the defendant slash counterplaintiff, says that this subsection 8 means that interest is calculated on the full amount of the judgment without reduction for payments. Well, subsection 8 has a lot of verbiage in it, but I think the language we can isolate that ARC is relying on is the language or the sentence that says interest under this subsection is calculated on the entire amount of the money judgment, including attorney fees and other costs. So ARC says that that means that you never reduce for payments, you just keep calculating interest on the full amount of the judgment. I don't think it says that. What it's talking about, I think clearly, is you have to have a starting total where you start calculating the interest. And in case there was any question, the statute is telling us that that starting total is the money judgment, including attorney fees and other costs. But the statute doesn't really tell us what to do after that and how to deal with payments made and the actual ongoing interest calculations. Well, so we're left to other devices to figure that out. One thing I would turn to is the one thing that I remember from my minor in economics from the University of Michigan, and this is really the only thing, and that is that interest is the cost of using money over time. So that means that once a payment is made, the time that that money is being used has ended that portion of the money. And that's the basic concept of interest. So if the money's been paid back, or a portion of it's been paid back, then you have to cut that amount of money out of the interest calculation. Now, I don't just remember that from economics. It's also, I think, supported in the case law, and the very case law that ARC cites. So they've cited the Cadwell case, C-A-D-W-E-L-L, and that case actually is not dispositive, because that case is really only talking about and ruling on those 6-month intervals and whether you use 6 months from the filing of the complaint and every 6 months thereafter, or whether you use a partial period and you go with January 1st and July 1st on the calendar for every 6-month period. So really, Cadwell doesn't tell us much of anything about the issue that we have here. But they cite this case, N-I-G-G-E-L-I-N-G, in the Cadwell case, and that tells us a lot more, because that case has the following language in it. Partial payment stops the accrual of interest only with respect to the portion paid, not to the entire amount determined due. And then later on, they say, on the facts of that case, they say the defendant tendered payment only of the undisputed sums. Those payments stopped the accrual of interest only with respect to the amount paid, not with respect to the entire amount later found to be due. That seems to me to support this basic concept of interest and how you calculate it. Now, ARC says, well, it would be an accounting nightmare, but interestingly enough, right in that case, it says, and I know this is not talking about the particular subsection 8 of the statute that we are here, but as I've already indicated, I don't think subsection 8 answers our question here at all. So here's the language in this case. Michigan follows the Massachusetts or United States rule in computing interest. A partial payment is applied first to interest due. If the payment exceeds the interest, the surplus goes towards discharging the principal, and the subsequent interest is to be computed on the balance of the principal remaining due. That's what we have. So I understand the point that the interest is supposed to encourage people, if you will, to pay judgments swiftly. And that's exactly what the interest does. It encourages people to pay their judgments swiftly, but it's not a punishment or a sanction. And so if you don't give credit for the payments that are due, not only are you violating the basic concept of interest as use of money over time, but you're also imposing a punishment or a penalty that isn't called for by any reasonable calculation of interest. So I am, and I can't vouch for the actual calculation. I know it's a bit of an accounting nightmare, but that is how you do it. I'm happy to learn that there is software that's used that does it for you, and no one's really questioned the plaintiff's software or what has happened as a result of that software. It's just this legal argument. So I trust their software calculation has done it correctly with this legal concept of credit for payments as they're made. And for those reasons, I am, upon payment of the amount of, lost my note, the amount that, of $1,317.92, I'll sign an order that the judgment is satisfied.
Thank you, Your Honor. And I do have this check. Ms. Gray, can I deliver that to you today?
Yes,
Okay.
you may. And Your Honor,
Yes.
thank you for the ruling. It would not be correct that we couldn't follow his software. So it's not that we didn't dispute his software. We did dispute his calculations.
Well, yeah,
We couldn't follow
I think we resolved the disputed calculations. I'm talking about the calculation of the interest.
Right. Well, if it's okay with the court, I'll just take a minute after this hearing to apply the court's analysis and make sure that we're all on the same page. And I guess if I need to present that in a motion for reconsideration, I'll do it through that avenue. But I do appreciate the court's ruling on our legal question.
Thank you.
Thank you, Your Honor. We will submit an order. Thank you.
Thanks for the court's time.
Thank you.
You're welcome.
Bye-bye.